Hey out there, legal warriors. You know what I've learned over the years? I've learned that there's two whys we have to worry about in every persuasive situation. And the two whys work differently in convincing someone in a normal case than in a restraining order case. And it's taken me the last 2 years or so to learn that from trial and error and trying to help people with restraining orders. Sure, if you're interested in these two whys, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, always, I'm just going to jump right into it. Yeah, we do criminal defense, but we also do restraining orders. But first of all, let's talk about persuasion. I think there's two whys that most forms of persuasion happen, especially in the criminal law or in a fact finding. And I think one why is sort of physically why something couldn't have happened, right? Hey, I couldn't have run the red light because I wasn't even driving the car, right? So why didn't you run the red light? Because I wasn't even driving the car. So I'm trying to persuade a fact, right? Why am I not guilty of assaulting someone? Because that person hit me first. Okay, so that is trying to use logic that, if A, then B, or if not A, then not B. Okay, and so that is easy for a trier of fact to follow. And I think those whys are very important in every type of case. Let's call it the logical why. The logical why one thing physically either did happen or didn't happen based upon physical evidence. Okay, and now there's a second why. The second why, I think, is about motive. Why does someone do something? If someone has more of a motive to do something, then maybe it's more likely that something's true or something's not true, right? That's what we think about when we watch true crime. I watch a lot of true crime. Shout out to that chapter out there. He's very good with going over a lot of true crime and the whys and the motives. And in big cases, when we're trying to, when we have time for testimony and we have a lot of time to think about things and there's juries involved, motives are pretty important and can be maybe one of the most important things. So the why someone might do something might make something more likely to be true or not, right? So the husband might murder the wife, and if there's life insurance, that might be one of the motives. So that why is sort of important. Why did the husband do it? Well, they were getting a divorce, and there was life insurance, and the husband didn't want to lose the kids, and he was crazy too, right? But so those sort of whys are motivational whys. And you would think that both whys are equally powerful all the time and should be used all of the time. And I think that's true for criminal cases. But what I've learned, and that's part of the title here, is that in restraining order cases, I do not think both whys are equal. And that's something that we're learning. The more thorough job we do on restraining order cases, the more I'm seeing how the nature of a restraining order hearing sort of makes the first why far more effective than the second why. The logical why about if A, then B seems to be more effective than the motivational why of why someone might be lying in their affidavit against someone. So what is a restraining order? Restraining order is where the petitioner, just a human, not the government, says, hey, I've got a problem with the respondent. I want the respondent not to contact me. I might want them thrown out of their house. I may not want them to contact their kids, not come on my property. There's domestic violence restraining orders. They're called protection orders under the law, but we call them restraining orders out in the world. Domestic violence, stalking, harassment, sexual assault, vulnerable adult, a bunch of things like that. But the nature of the hearing is it's pretty much done on writing, right? You can watch some of my other protection order videos, restraining order videos. We talk about, the court reads a petition, and then the court, which is the claims against the respondent, and the respondent has a chance to file a written response, and the court wants these things in writing. And what I found is the courts have so many of these hearings on at once. They might have five in a day, 10 in a day, might have 10 in 2 hours. And so there's not a lot of time for the court to get deep into motives. There's only a little teeny part, I think, of the brain of most deciders that are available for each case. And in my opinion, it's the logical side, especially if we're on the respondent side of this. I'm the person who's trying to fight the order. It's really important to include, hey, this couldn't have happened like the petitioner says. Why? Well, here's a text message that says it didn't happen that way. Why? Because here's a witness statement that says it didn't happen that way. Here's my testimony that says it didn't happen that way. And I think the court has room to see that and to analyze and process that without sort of developing oppositional reflex to that, because you sort of done on feel these things. And this is a sort of advanced video, but it's very important because it's stuff I've had to earn over time, this learning. When we start to get into what so many people want to do, the motivations, because it makes sense, right? Hey, here's the motive of the petitioner to lie. They just want to throw me out of my house because they've always wanted the kids. Don't believe that the petitioner said I hit the petitioner because they're just making it up because they want me out. That just sets up problems. If you start to guess the whys, it's so easy for the whys, for the motivational whys. It's so easy for the judge or the trier of fact to just go, nah, you don't know that. It could be any reason. It's probably because they really got hit. You're asking them to surmise something when there's not enough time, there's not enough testimony, there's not enough evidence for them to make a logical decision about that. And therefore, typically, I think it hurts your case if you get too deep into the motivational whys of why someone's lying. It just rings hollow. It sort of seems whiny. It seems like it's desperate. Okay. I think a line or two in a response is good for an idea. It's possibly because of this. If we can say it's possibly something and not beat it to death, then I think it's more likely that it won't hurt our case. So the two whys in a restraining order type hearing, we need to focus on the logical whys, why it couldn't happen how they said, because that's what I think the court's brain has room for, given the short nature of this hearing. They're usually 5 or 10 minutes, and the amount of pressure on the court to make a factual decision. The more we ask them to surmise, to guess, when there's a million different motivations, and there's a lot less options when it comes to facts, I think it hurts us. And I think it makes the court shut down and not look at our filing nearly as seriously as far as the logical whys, because we're just stretching. You never want to ask the decider of fact to do more than they need to do to find on your side. You don't need to win at 100%. You need to win at 51% because these are preponderance of the evidence. So get enough of the logical facts in there, why it couldn't have happened how the petitioner said. And please don't really rely on the motivations of why they're making it up. Now, if you've got smoking gun text message that says why the motivation is, I'm going to lie about you on purpose and hit myself in the face on purpose because you didn't do X, Y, and Z. If they've ever threatened that, and I've seen a case where that text message exists, then let's use that, okay? But I just think it's really important because these restraining orders are so hard and we really don't know what to do if we're served with one. It's important to focus more on the facts of the case. We need some emotion in there, but less on demonizing the petitioner about why it is they're lying. Let's just show they're lying, and we don't really care why. We can whisper about it, but let's not shout about it. Okay, so I hope you found that useful. That's just my opinion. It's sort of a eureka moment for me over the last month or so. And this is the best way. And the first way I've tried to explain it, I might be able to do it better later. But if you found this useful, please like and please subscribe. More people get the help they need. And more importantly, if you got a crime in Washington State, you got to serve with a restraining order. And if you need a restraining order, feel free to give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.